The NARA bill gives the Prime Minister the authority to overrule government agencies and local authority. So the parish council gets a plan for a NARA project and they don't want to pass it or they don't pass it. The Prime Minister can pass it as if it is the parish council that pass it. NEPA gets a plan and NEPA said, no, this is going to damage the environment. The Prime Minister can pass it. Well, before I go to Marshy, the Prime Minister has done that before. The Prime Minister has done that before. NEPA, Forestry, said the Dry Harbor project should not be passed. Andrew Holness passed it. I'm going to play what the court says. I'm going to RGR beyond the headlines with this lady here, Diane Jackson Miller. She was reading from the ruling of the judges. Open the line. Listen this.
Additional reactions to the Constitutional Court's ruling for the Bengal mining lease. And it's a 94-page judgment. It's a very, very thorough judgment. And the court, during the judgment, points to the regulatory authority, that's the Natural Resources Conservation Authority, is having refused the application for the permit. The authority expressly stated that the proposed development should not be approved and identified likely harm to natural resources and public health. They made reference to what they call the trenchant objection from the Forestry Department, identifying irreplaceable loss of dry limestone forests, failure of post-quarry reforestation efforts at other sites, and the importance of the forest, including oxygen production, water filtration, and so on. And then they go down, they say a little later on, and I want to read this because this is really important. They speak about the minister's treatment of the environmental evidence. And of course, this is the minister of what was then economic growth and job creation, now economic growth and infrastructure development, which is the prime minister. It said, and it speaks of his treatment of the environmental evidence. It says the concerns before him were considerable and wide-ranging. They covered biodiversity, hydrology, air quality, public health, scenic value, and the impossibility of restoring the lost forest despite any post-quarry rehabilitation efforts. The NRCA is a body charged by law with environmental protection. Its assessments carry substantial weight. The court said it is not saying that the minister has to agree with the NRCA, but once he chose to disagree, there had to be a clear evidence-based reasoned justification for doing so. There has to be something explaining why the authority's conclusion was wrong, overstated, or sufficiently answered. There is no such reasoning before the court. And the court said the minister hearing the appeal remained bound by the Constitution. And let me
hear that. The judge said the Prime Minister never care about when NEPA and Forestry say him pass the bill. Well, the court fling it away. It shows why we are in a low trust environment. And we don't trust Prime Minister Andrew Michael Radam Brogard Holness. Marshall.